Hello, my name is Michael Tesoro and I prepared this video presentation entitled Digging Yourself Deeper, ASIC and Tzouvelis. And the reason I call it Digging Yourself Deeper is it just appears to me that the respondents in these particular cases are doing such things as to create many more problems for themselves and potentially looking at criminal prosecutions going down the track. And maybe it's time to have a rethink of their strategy and to be more cooperative with ASIC. It also raised some interesting issues about the way the crime and fraud exception operates in relation to claims of legal professional privilege. So I thought that was a worthwhile thing to have a look at. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice, Tzouvelis Legal Consulting, for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline of the case is pretty straightforward. Look at the background, which is effectively the earlier court case back in 2017, which involved Golden Financial Group, and then look at the current proceedings involving Mr. Tzouvelis, and then finish with some commentary. Now, the earlier case involving ASIC and Golden Financial, and it referred to a company, NSG, which was the former name of this company, and there were various allegations made by ASIC that NSG had breached various provisions of the corporation's law. Firstly, breaches of section 961B and 961G, which relates to the provision of personal advice to retail clients. Then there was also alleged breaches that NSG failed to take reasonable steps to ensure that its various representatives complied with those two provisions. And finally, there was allegations that there'd been further breaches of another provision of the corporation's law, section 961K. Now, what occurred was the civil penalty proceeding was commenced against ASIC back in 2016, and effectively there was consent orders agreed to and put to the court. And Judge Mashinsky agreed to make the various orders, which included a payment of pecuniary penalty of $1 million in relation to those contraventions. There was also an agreement to pay $50,000 to ASIC for investigation costs and a further $50,000 for legal proceeding costs. But what happened was only $100,000 of the penalty was paid, leaving $900,000 outstanding, and all of the costs payable to ASIC were paid. Now, these current proceedings, ASIC and Tzouvelis, involve a claim that when ASIC conducted a search warrant at the premises of Mr. Tzouvelis, they identified a number of documents which they believed were relevant to their investigation, but over which Mr. Tzouvelis claimed legal professional privilege. So there were 615 documents held on electronic devices which were not handed over to ASIC. And ASIC has taken these proceedings to seek declarations that these 615 documents are not privileged because of the fraud and crime exception. So in other words, these documents were generated to further an improper purpose, and as such, legal professional privilege did not apply. Now, this search warrant was executed as a result of a further investigation by ASIC into Mr. Tzouvelis' companies. And as you can see, there's a wide range of provisions that are now being looked at. So I guess looking at those different provisions, 911A is a requirement having a Australian Financial Services licence. 61B is acting in the best interests of your clients. 1041G, 1041H are in relation to providing false and misleading statements, dishonest conduct, stuff like that. Section 13, that's in the judgment. I think you can actually breach Section 13. That's a general investigatory power of ASIC, so I think it might be a typo. And then you see there's some breach of the Crimes Act, so 8283A, obtaining financial advantage by deception, falsification of documents, and Section 35, giving false testimony. As you can see, they settle the civil case, engage in some shenanigans in relation to the business, and then end up getting investigated again for a wide range of very serious contraventions, much more serious than the initial contraventions that they settled. Now, the fraud and crime exception is discussed in the case by the judge, and the key case obviously there is Commissioner for the Australian Federal Police and ProPend. And it firstly pointed out that it says it's an exception to the legal professional privilege, but it really isn't. Rather, due to the illegal or fraudulent objective of the communications, it means that privilege never actually attached to those documents. So effectively, there's a conclusion, if the fraud and crime exception operates, that the documents were never privileged. And as you can see there, that it's refers to fraud and crime, but actually it includes a much, I guess, lower level of conduct. It, as Brennan said in the Pro-Pen case, it applies to some illegal or improper purpose. So it isn't necessary to show a fraud or a crime, maybe just some illegal or improper purpose. Then there was a case of ASIC and Mercorella, which Mansfield looked at the issue of whether improper conduct could be seen to extend to putting assets beyond the reach of creditors, and he concluded that that would be an improper purpose. So evidence that a person has sought to put assets beyond the reach of the legitimate claims of secured creditors would be improper purpose, thus invalidating a claim to legal professional privilege. Also, it's important to note that for a document of communication to be made in furtherance of the fraud or proper purpose, it must help forward, advance, or aid it. So I guess it sort of doesn't have to be necessarily the key communication establishing some illegal conduct. It can just be a step towards pushing along that improper conduct. And then finally, the onus of proof, and it's relevant here that it's not the balance of probabilities. Rather, it's a much lower onus of proof, which is effectively the prima facie test. So you've got to prove on the prima facie basis that there's an improper purpose, and thus the documents are unlikely to be subject to a valid claim of legal professional privilege. Now, the two questions the court had to consider. The first was a question which had two parts. Firstly, whether ASIC had established a prima facie case that Mr. Tzouvelis had acted in furtherance of improper purpose by diverting assets from his company to a third respondent in order to minimise the assets available to it to pay ASIC the pecuniary penalty, or I should say the Commonwealth Government, the pecuniary penalty of $900,000 that was outstanding. And secondly, whether they were made in furtherance of a proper purpose of causing Mr. Tzouvelis to file and serve misleading evidence and written submissions about the financial position of the company in the earlier civil penalty proceedings. And the final question was whether do any of the 615 identified documents over which privilege is claimed contain evidence, communications between the respondents or any of them and the legal advisors in furtherance or as a step preparatory to either of those improper purposes. Okay, so the court will determine question 1A and B, but not necessarily determine question 2, and I'll explain why not later. Now, the real reason for the belief by ASIC that there'd been improper purpose was there was a transfer of funds from Golden Financial to another entity of $821,000, and that was 3 weeks after ASIC commenced proceedings. So that was the first thing. And also there was further evidence put forward by Mr. Tzouvelis claiming that that transfer was due to various services provided by this other company, Premium, in terms of management services to Golden Finance. So there were a bunch of invoices that amounted to $821,000, which were alleged to be for management fees that were incurred earlier. And I guess ASIC's view with these sort of liability, these management fees, sort of appeared out of nowhere. There was no previous indication these fees were payable by Golden Financial. Now, in Tzouvelis' affidavit, he starts explaining the impact of ASIC's earlier case on the Golden Financial business. And as you can see, a lot of disruption was caused by ASIC's investigation and prosecution. They had difficulty in obtaining professional indemnity insurance, which sort of makes sense. So he got together with the management of Golden Financial, decided they could not continue to adequately service its clients in a manner consistent with their financial services obligations, and therefore they concluded it was not a viable business and its remaining clients were at risk of suffering loss. So therefore they made the decision to move the clients to premium. So pretty openly explaining that the company had no longer a viable future, and therefore we're going to move all the clients and also assets to another entity. And that raises lots of questions when you have consented to paying ASIC a fine of $1 million. So what ASIC submitted in response was that Golden Financial was assigning its interests in various distribution agreements to premium for no consideration. So effectively, Golden Financial had acted as a mortgage broker and provision of financial services advice, and had given business to a number of other financial institutions, and they're entitled to what they call trailing commissions. So it's continuing commissions on all of those mortgages and loans that goes forward for the life of the loan, and they're quite valuable, quite a large amount of money. So what's happening here, Golden Financial is contacting a lot of different lenders and saying, could you start paying these trailing commissions to this new entity and not to us anymore? And a number did agree, a number also resisted. But the fundamental point here is, how can one company assign its interests in these distribution agreements or trailing agreements to another company for no consideration and claim that's effectively a valid transaction? Also, Premium had consequently received trailing commissions well in excess of $900,000 owing to it. I think it was approximately, what it says there, $4.9 million. So effectively they transferred ongoing income to Golden Financial of $4.9 million from Golden Financial to Premium without any consideration. So ASIC said that was evidence that there was an improper purpose. So the conclusion reached by the judge in the case was that ASIC had made out its prima facie case that the respondents had acted with an improper purpose of diverting assets from Golden Financial to Premium to minimise the assets available to Golden Financial to pay the pecuniary penalty. So the judges conclude on a prima facie basis that ASIC has established that Golden Financial and Mr. Tzouvelis were moving money out of Golden Financial to avoid having to pay ASIC, or paying the Commonwealth Government, the remaining $900,000 of the penalty. And I guess there's other issues there as to whether other creditors may have been subject to losses when they move out all the revenue from Golden Financial. So that isn't discussed in the case, but you'd assume there might be some other creditors there who might have their claims defeated. And then, as you said there, more probable, the lump sum payment of 20 months worth of invoices totaling $800,000 to Premium 3 weeks after the civil proceedings were commenced was made in order to minimise the assets available to Golden Finance to pay the pecuniary penalty. Now, admittedly, this is on a prima facie basis, but the judge was satisfied that this appeared to be a bit of, asset stripping from the company to avoid a liability that had been incurred in the court. Now, question B is the question of whether there was evidence of false information being provided in the earlier case. And as you can see there, the judge was satisfied that ASIC again had made out a prima facie case that Mr. Tzouvelis and other respondents had acted with an improper purpose by causing Golden Finance to file and serve misleading evidence and written submissions about its financial position. So there's allegations here that they filed evidence in the earlier case about its financial position in order to minimise the amount of penalty it had to pay. And as you can see here, the judge has seen, and this is referring to some of the evidence in the case, that Mr. Tzouvelis wrote to 2 other people, and in his email he made the comment that what has been done, namely the creation of the $3 million in equity, doesn't look like a profit. So they've got to try and make sure that this amount doesn't look like profit, because the less we show, the less we fine. So he's clearly conscious of the fact to make the company look unprofitable so that the fine will be lower. And then you can say the judge says open to infer, based on this evidence, that they were seeking to ensure that ASIC was led to believe that NSG did not have sufficient money to pay a larger fine. So the evidence was there that they're sort of providing submissions and affidavit evidence to ASIC as part of that early civil proceeding case, which indicated that the company didn't have very much revenue when that wasn't actually the case. And some of those documents are quite damning because they're suggesting there was a consciousness of what the individuals were doing. So the conclusion that the judge reached was that the omission of any mention of the fact that the trailing commissions worth many millions of dollars, so almost $5 million, had been assigned to from Golden Finance to Premium over 4 years seems, on a prima facie basis, an obvious enough matter to have mentioned in a complete explanation of Golden Financial's limited capacity to pay. So effectively, in their evidence to the federal court in the earlier civil proceedings case, they hadn't mentioned that they'd been transferring all these trailing commissions worth over $5 million to another entity for no consideration when they were seeking to explain their ability to pay a large fine. So clearly the judge was satisfied, and again on a prima facie basis, that this was misleading evidence provided to the court. So the disposition of the matter, and this is a question 2, is that the judge decided to forward the matter to the Senior National Judicial Registrar to examine the 615 documents which are the subject of the dispute and work out whether they are properly the subject of a legal professional privilege claim. Now, that means to look at the documents and to work out one of two things: whether the documents, which are most likely from legal advisors or to legal advisors, disclose evidence of the plan to divert assets from Golden Financial to Premium in order to minimise the assets available to pay ASIC the penalty of $900,000 that was outstanding, or causing the respondents to file and serve misleading evidence and written submissions about their financial position. So the registrar's got to look at all the documents with this current judgment in mind and make a conclusion whether the documents do actually suggest either of those two improper purposes, and if so, report back to the judge on the findings. And clearly the implication will be, if the registrar finds that these documents were not properly the subject of a claim for legal professional privilege, they'll be handed over to ASIC. So just a bit of commentary. I guess it seems to me that this company is digging a much deeper hole for itself by its conduct in this case. It sort of agreed to pay a penalty, but it sort of appears to have provided some misleading evidence to the court as to its financial ability. It's transferring funds away. It seems a bit like financing activity, effectively. And it's digging a much deeper hole for itself. It's facing a second investigation, a much more serious investigation than the first one, looking at personal penalties, but also potential criminal prosecution, potential jail time as well. So in order to avoid having to pay the penalty, it seems to create so many more problems for itself. Clearly, there are implications for a variety of people if these documents do show an improper purpose, and various people could have questions to answer in relation to that. So it seems strange to me that in order just to maybe avoid paying a pecuniary penalty, which they maybe were quite able to pay given the amount of trailing commissions they had in the business, they've engaged in all this conduct which is possibly going to see them criminally prosecuted and could end up having some jail time. An interesting issue also is that the fraud and crime exception is subject to a fairly low onus when you think about it, because firstly, it doesn't have to be a fraud or a crime. It can be any improper purpose, which obviously encompasses a range of conduct of less seriousness, but also the allegations had to be proven on a prima facie basis. So it's fairly low onus. So it's probably surprising to me that more regulators don't make this allegation in cases, particularly when they're executing search warrants, because it seems that it probably have fairly good prospects of getting the documents to be at least looked at by a senior registrar and a determination made as to whether they're subject to a valid claim of privilege. And I know when I worked at the ACCC, there were cases where various companies would claim huge amounts of documents as subject to privilege, and you were very suspicious as to whether they were valid claims, but really we never pushed the issue and never found out what these documents said. So that's all I had. Hopefully that's been helpful, and it's an interesting case, and to be aware of this fraud and crime exception and how it operates in particular cases. If you have any questions, feel free to give me a call or send me an email. Bye-bye.